Hello and good morning, everyone. I welcome today to the class of Private International Law, which would be taught in the ninth semester. It is a new subject in the international area, so I hope you will like this subject. And today we'll start with the introduction. We'll start with a short introduction to the PIL. How did it came in the world, and what is its necessity, and most importantly, what is private international law. So these are the things and topics that would be covered today. I hope you'll enjoy the class. So let's begin first with the introduction to the private international law. So private international law or international private law governs the choice of law to apply when there are conflicts in the domestic law of different countries related to private transaction. This means that there is a dispute or transaction that involves one of the following. So basically, a private international law is a conflict in the domestic laws of different country. And now what it says that it is a dispute, and the disputes are as following. Number one, what jurisdiction applies? So first of all, there is a problem of jurisdiction. Now, it is the court who will decide the jurisdiction, and also the court renders some power to the parties also, that they can decide under which court they should go. Next, we have the choice of applicable law. Then, what type of law would be applicable in that case? And next, recognition or enforcement of a foreign judgment. So, these are the most important elements of a private international law. So, when a case is there, so a court decides the case on behalf of these three elements. In the United States, Canada, and Great Britain, it is also known as conflicts of law. So, national laws are the primary source of private international law. Private international law is also embodied in treaties and conventions, model laws, legal guides, and other instruments that regulate transactions. Private international law deals with a variety of topics such as international contracts, torts, family matters, recognition of judgment, child adoption and abduction, real property, intellectual property, etc. So they cover in the various arena. So private international law is basically a conflict between two private individual. When two private individual are in a conflict, then there is an arise of the private international law, and that private individual should be the citizen or domicile of two different nationalities. Then only it will give an rise to private international law. Okay, so next, so laws are the international law and municipal laws. In between lies somewhere the field of private international law, dealing with conflict rules caused due to presence of some foreign elements. There lies no man land in between international law and domestic laws. This is where private international law fits in. None applies here or both apply here. Their interaction is regulated by rules. These are called conflicts of rule. Now it becomes third branch of law, nearer to both but distinct and separate in nature. So let's take an example in a divorce case when a court is attempting to distribute marital property. If the divorcing couple is local and the property is local, then the court applies a domestic law, which is also known as lex fori. So this is a very simple case, but this case can become complicated if the foreign elements are thrown into the mix, such as when the place of marriage is different from the territory where the divorce was filed, where the parties, nationalities, and residents do not match, when there is a property in a foreign jurisdiction, or when the parties have changed residence several times during the marriage. Now, in such instances, private international law comes into existence because there are no other law which can decide this matter. Next, most other countries, the term private international law is used. Conflicts of law is usually refers to domestic laws that are not part of international laws. And the calculus only includes international law when the nation has treaty obligation for countries that use the private international law terminology. It comes from the private law public law dichotomy in civil law system. In this law forum of legal system, the term private international law does not imply an agreed upon international legal corpus. So I hope you are understanding it. Okay, so next, it is a branch. Now, what is a private international law? What is its existence? It is a branch of jurisprudence arising from the diverse law of various nations that applies when private citizens of different countries interact or transact business with another. So, I've given you an example of a case of a divorce. So, a divorce between both between the husband and a wife is simple if they both marries in same countries, they apply same laws and have the property in the same country. But it becomes more and more complicated when they are of different nationalities, the place of domicile is different, the property situated is different. So this is where there is a need of private international law. Private international law refers to that part of the law that it administered between private citizens of the different countries or is concerned with the definition, regulation and enforcement of rights in situation where both the parties in whom the right inheres and that the person upon whom the obligation rests are private citizens of different nations. So this is very important. So we can say that it is a set of rules and regulations that are established or agreed upon by citizens of different nations who privately enter into a transaction and that will govern in the event of a dispute. In this respect, private international law differs from public international law, which is the set of rules entered into by the government of various countries that determine the rights and regulate the intercourse of independent nations. So, therefore, we can say or we can conclude that private international law or conflicts of law is that branch of law, in some aspect public, in other regulating all suits involving a foreign law element, where a difference in result will occur depending on which law is applied as lex causa. So, firstly, it is concerned with determining whether the proposed forum has jurisdiction to educate and its appropriate venue for dealing with the dispute. Now, secondly, it will see that it is concerned with determining which of the competing states and which laws, national or municipal or conflicts law, are to be applied to resolve the dispute. And next, thirdly, it also deals with the enforcement of foreign judgment, foreign awards, and foreign decrees. So, this three is very important. So, this is all for today. I just gave you with a short, brief introduction about private international law. I hope you understood something about private international law. If not, we will continue with the same in the next lecture, and I hope you'll get some idea and you will clear some doubts regarding private international law. So I'll conclude my lecture for today. I hope you had a great day. Stay safe and please always wear a mask. Thank you very much.